My dear participants, it's a pleasure to come to your place in Sikkim Judicial Academy, and I owe very much to my participants, particularly who are working in the judicial system of India. Now, the situation where we are trying to discuss or present is something very new. What we used to have, the traditional crimes or traditional frauds, everywhere there is a profitability, the finance was there. But there the traditional methods of crime and the modus operandi was quite different when we talk about cybercrime. You being the judicial officers of Government of India or Government of Sikkim states, your interpretation at this stage of cybercrime menace or combatement is very important. What we have noticed is that you will be seeing that the major portion of Information Technology Act 2000 has been modified and repealed, and also we have different types of amendments coming up, and the amendments coming out of the inference or commitment by you only, the judiciary. I remember there are certain incidents of arrest. Everything in India, when we try to combat the enforcement activity, we uphold the constitutional values of the citizens. If you look at the question of arrest, prima facie, it is actually curtailment of freedom to the citizen, free movement of the citizen. In fact, I was in the enforcement for about 39 years, and my subject was commercial fraud. And my subject was mainly the financial, the smuggling and evasion of customs revenue or duties. There we found that suppose say we arrest a person in 1970s and 80s. What we used to do is, we just prepared the papers, we used to do formality of investigations, inquiry and all, and then we put him inside the bar. After 1997, the officials, judicial, they interpreted something different, and by which, if you look at particularly the main inference or the citation, State of West Bengal versus D.K. Basu versus State of West Bengal in 1997. There, mind it, we were working very freely. There is no activity. But only after 1997 judgment, when the constitutional bench was created, and they upheld the constitutional values of the country. And there, the first and foremost thing was the ground of arrest. Look at this. We are performing our duties. We are doing our investigations. But after 1997, the judicial involvement came up, and they come up and they said, look, it is against the principle of fundamental right, Article 2021. So, when you are trying to curtail the freedom of the citizen, you have to abide by certain formalities, and then the ground of arrest started. Now, as on today, if you fail to give the ground of arrest, informing them the exact sections of the law and the contraventions so far made, or revealed, your arrest will be void ab initio. Mind it. So situation has changed. And ground of arrest is a must. And similarly, in the digital crimes, or cyber crimes rather I should say, this is yet to be formulated. I don't mean the ground of arrest. CRPC is very much there. And now, as you know, that this Bharatiya Surakha Citizen Surakha Sanghita, that is CRPC, that is there. So, ground of arrest is a must. Similarly, if you look at the sections of the law, there are changes. You will find the cybercrime case. The extraterritorial jurisdiction has been earmarked under the law. If you look at the section 1 subsection 5 of the IT Act as amended, you will find that extraterritorial jurisdiction is very much there, but not in other crimes. Say for other economic crimes, this has not been activated yet, unless there are certain conditions fulfilled. But here, when you talk about cyber crimes, the extraterritorial jurisdiction has been earmarked. Why? Because if you look at cyberspace, the mens rea, the culpability is yet to be understood. Because you don't have any physical connection. It's all virtual. The crime has been made, the activity, the presentation has been made in India. And the person concerned sitting in US. So unless there are certain bilateral treaties, the extradition will be very much difficult. You have to make a lot of political treaties and political involvement so that extradition of the criminal could be activated. We will just try to discuss certain cases, and there we will find that it differs quite a lot. If you look at other criminal activities, other crime, other financial activity, illegal activities of finance and other things, it's a quite different situation. So I have just got certain presentation under the session. Cyber crimes, emerging jurisprudence and judicial response. Now you see, the act is very much there. See, I'm going to share this presentation to all my participants. You can take care of this, but we'll just discuss the matters, okay? Now what is cybercrime? Cybercrime refers to any unlawful act where computers, network and digital systems are used as tools. Used as tools, targets and means to commit offences such as fraud, data theft, unauthorized access or disruption in violation of applicable laws. What does it mean? That means when you enter any house, what happened? We ought to have a warrant. We have to have a permission or approval from the housekeepers. Now in the digital world, if you want to have access, you have to have certain key points. What are the key points? That means access points. What are the access points? That means you have to have some password. Now, if the password if I know the password, I can have my access. So that means I have to collect the password for hooks and by crooks. Once I get the password, then I can have the access to your system. No matter where I am, I may be thousand miles away, but I can have access. So that is called phishing. What does it mean? Unauthorized access or hacking of computer network. What for? That means what are the data put into the system, whatever the password is there, what is the methods of what you call blocking or key password or OTPs or whatever, I have to have that. So cyber fraud, that is called phishing, online scam and financial crime. And that is normally, we call it as a malware. Now I can just tell you, sometime in the year 1995, mind it, so long back, the first victim was my son. The first victim was my son. It was in the year 1999 or so. He was working in Bangalore. He had the accounts. He just gave me a ring in Kolkata. He said, "Sir, Daddy, I have lost 1,50,000 from my savings account." I said, "Wow." I said, when I opened my laptop, I found that the system asked me, the bank people asked me some of my system, I mean what you call password or the access points. And he communicated that. But exactly in the malware, the bank's identity, the query from the bank is very much there in the system. He could not make any doubt on that. So he just put it there. And immediately the perpetrators have taken away the money in, 3 or 4, times. Then what has happened is, he phoned me up. I was in the department that time. So I requested one of my colleague in CBI. And he communicated to the person bank. And somehow, now I am going to discuss the sections of the law. Now in 2025, the act is there. The contravention is very much there. And the bank is obligated to give you the compensation. But that time, after about 6 months or so, I could avail the compensation. And that is with influence, mind it. But now you need not go for any influence. It is the responsibility of the bank people to have their responsibility obligation, mandatory, as per the IT Act, as per the IPC, as on Bharatiya Nyaya Sanhita. So, this is what we are trying to project it. Cyber stalking, online harassment, defamation. You will find online harassment, defamation. Every of your family members or colleagues must have faced this. One of my colleagues faced the same thing. He was my colleague's daughter. She was a lecturer in a college, and some students or whatever created some, communication, healthy communication, and said defaming her. Now how to get the protection? The protection is very much there. You have to go for CERT, cyber crime, research, emergency portal. You can report it, CERT2. So immediately the activity will start. But in those days it was not there. So every day we are stepping up and developing the ideas and things from home, from the interpretation from you only. When the case history comes to you, when the facts coming to you, you are creating a sort of interpreting law, and that is the law of the country. As we all aware that the Supreme Court, being the apex court of India, their observation, their judgments is the law of the country. No matter whether the sections of the law is very much there or not. Clear? Then, denial of service distribution. You go to the bank. You have 5 minutes time. You know after withdrawal of the money, you have to rush to your responsibility. The bank says, Sahab, there is no communication. The communication is failed. Online transaction cannot happen. Whatever, you have to wait. And by which? Who is defamed? The bank organization. The organization who is helping you, who is saving their resources. Their business is hampered. Because there has been denial of service, because there are a lot of disruption, advertisement. You will find in the laptop, you will find in the communication yourself. When you are working something, sometime some advertisement is coming in your system, and by which your total mind is upset that this happens. Intellectual property theft and software piracy. What is intellectual property? This $1 million question. Now, I have prepared some research paper. A scientist has prepared some research paper. His data are there. If data could be theft, could be stolen, then what happened? His $1 million will be lost. He has got the IPR. As per the IPR, intellectual property rights. And that is very much there in other enactment, other economic offenders and other things, offense cases and other things. It is very much there. IPR, intellectual property rights. And this is taken from international obligations. Like international obligations, 13 laws of the international trade. That is very much there. Obligation on intellectual property. But here what happened is, by means of stealing your data, and that particular research paper has been sold by the perpetrators, and he is earning money. Because everything in the digital system. Once I have access to the digital system, I can very much aware of your data. So for which we have made the enactments like Data Protection Act. And there the sections of the law is very much there. Online child exploitation and dissemination of illegal content, very much there, very much there. Your son, aged 4 years, sometime you will find he is playing some music and something is coming up in the system, and by which he is totally at a loss. That is very much there. So, cyber terrorism, including attacks on critical infrastructure. You will find that there has been a lot of incidents of damaging our infrastructure, like, what we call water system, then electrical system, all the infrastructure, digital system has been damaged. So all these protective measures will come up in our enactments. phishing attack by deceiving you into entering your username or password. That we are discussed. Malware is the malicious software designed to disrupt, damage, unauthorized access to the system. Viruses, worms, Trojans are very much active in today's situation. Spyware is a malicious software that secretly monitors and collects user data. You will find what happened. You will notice electricity department is sending a notice with the total format, asking him that if you do not pay 20 rupees, your entire connection will be disconnected by 6 o'clock tomorrow morning. The message has come to you in the digital system. What happened? You will find, yes, maybe there are 20 rupees, भाई क्या है 20 rupees दे दो. ये minimum 20 rupees के लिए इतना disruption, इतना difficulty face करने पड़ेगा, तो 20 रुपये दे दो, ये तो ठीक है, electricity company तो भेजा है, तो he just put 20 rupees online. Immediately you will find his bank was defrauded. That is called spyware. You will find in every system it is very much there. Cyberspace. This is what I was talking about, that I am sitting here and the crime is happening in USA. I am just trying to have a communication with a person outside the jurisdiction in India, and that communication has been spywared or malwared by some miscreants. And it encompasses computers, network, software, email, electronic devices such as smartphone ATMs. पहले ज़माना में हम लोग को बोलता था बैंक पीपल, ये साहब आप जब एटीएम में पासवर्ड दीजिएगा, नंबर दीजिएगा, try to see that nobody is seeing it or something, close the door. Now you need not do that. The protection, that protective activity will not be operating. Now with the system, that is the crime, the ATM, the OTP will automatically go to the perpetrators. So that is very dangerous. Now, they are actually, sometimes we used to say that, look, you are a cardiac patient, you don't run like that. Now you have a watch, smartphone, by which your every activity of the physical, ingredients will come up. So this is the digital system. You did not go for seeing what is your blood pressure or all these things. That watch will tell you that whether you need this or not. So digitalization will help you, will appreciate the development, but at the same time, unless you are protected, you are at a loss. You are at a loss. The information, keeping the information or data secret or secured is one of the most vital points in the cybercrime and the cyberspace. There you will find the smartphones, electronic devices are very much important devices where you have to be very protective and secure. Now this actually, we all are aware of this, social media, messaging apps, e-commerce, cloud storage, online banking, online entertainment, gaming, e-governance of portals. These are all very much there in the digital ecosystem so that the perpetrators is enabled to reach you and have access. ये जो ऑनलाइन सिस्टम है, इसमें particularly the banking, online banking, you have to be very careful. Have to be very careful. Now, what is the legal landscape? That is important. Now, legal landscape, you will find, particularly in the finance, in the banking system, the 2025 data indicated that India has lost, in India, people have lost about 8,200 crores in the finance sector, only in the cybercrime. So these data are very much, they are cybercrime predicted losses in 2025. Now let me share my submission before my friend participants that in today's situation of presentation or delivery, particularly in the training system, my clear suggestion to my dear participants are, don't accept the presenter's statement immediately. Please. You know, I was in the enforcement, and after my superannuation in 2003, I have changed my domain and I have in the academics. Now I became a very busy academician in lot of institute. Mind it, I was a law enforcing officer. I was a very successful officer in the department, recognized officer of the department by virtue of my own activities. And the activity was enforcement chapter. But I have completely changed to academics, and where I found is much easier rather than enforcement activity. Why? Because the informations are available in the digital system, in the cyberspace, so high that you can equip yourself. You need not go to the library to find out which book it is available. You simply go to the media, you simply go to the cyberspace, internet, and get hold of your answers. So friend, my suggestion is, though I am sharing this presentation to you, but please equip yourself when you make yourself available in the judiciary or in the enforcement. Try to have a cross-check with your digital system. Am I clear to you? It's my submission, it's my suggestion. Because I am not here to make a sort of commercial importance before you. At this age of mine, I have nothing to earn or nothing to deliver. My delivery is just, I am trying to engage myself to have a training so that my future generation could activate themselves in a very high standard. And that is why at this age of mine, I am still having a regular performance in the induction courses of my department, like customs, GST and others. That's my parent department. So friend, my suggestion is very clear. You have to equip yourself by browsing the information available in the cyberspace. What are the statutory obligations? Statutory obligation is foremost is IT Act 2000. When IT Act 2000 was passed by the government of India or President of India, that was quite different when you look at IT Act 2020, Amendment 2023. It's quite different because what 2000 has been there, after the judicial interpretation of several cases, several incidents, several modus operandi, we have tried to modify and amend the sections of the law. And I'm sure that my friend will see within a very short span of time, India is going to make an absolute digital act. Absolute Indian Digital Act. I need not go for IT Act, IPC, CRPC, all these things. I have to have only one act to combat cyber crimes. You must be aware, in the Parliament today, we are yet to get the passing order of this Data Protection Act 2025 rules. Rules are yet to be finalized by my Honorable Parliament, which is still at discussion. What is the crisis? Crisis is one. That is, it is not at par with Right to Information Act 2005. Right to Information Act 2005. Under the Right to Information Act, there are certain mandatory obligations of the states, wherein the opposition party or the political party or the research people found that there could be some hierarchy in the administration who is going to have some activity which will jeopardize the interest of the citizens of India. Because it is not very clear with Information Act 2005 and the Data Protection Act 2025. That is why they are still discussing whether the rules will be clarified or not. We have prepared 2023, which was passed. Data Protection Act. The rules. What is the difference between Act and rules? You are very much aware. Act could not be implemented properly unless the rules are framed. Rules will tell you what to do. What is the SOP, Standard Operating Procedure? But rules are yet to be finalized, but the Act is already finalized. There they said that you will find fiduciaries. Who are fiduciaries? That means I have my own data, I have created my data, individual, and my data has been sold to you as a fiduciaries. The responsibility of fiduciaries is yet to be finalized in the matter of rules. These are the points that discussing. So, my dear friend, when I talk about statutory framework of cybercrime in India, the major portion is Information Technology Act as amended 2023. Number one, Indian Penal Code, that is called Bharatiya Nyaya Samhita. Then Bharatiya CRPC, that is called Nagarik Suraksha Samhita. Then Bharatiya Raksha Samhita. All these, that is IPC, CRPC and another? Indian Evidence Act. So these are the three sections which is very much pertinent when we talk about enforcement of frauds and crimes, so far as India is concerned. So this is very important. There you will find together forms a legal framework for addressing cybercrime, providing substantial provisions for investigation, prosecution, regulation of cybercrime offences. Investigation. Now, it is one of the critical situations where we really fail to investigate properly so far as the cyber crimes are concerned. Because Evidence Act says that the documents, you have to have a documents as evidence. And what is documents is very much there. A stone with something written, whether the stones can be identified as documents. Yes. The definition under the IPC, definition under the cybercrime, this IT Act is very much there. What is documents? What is facts? Facts has to be investigated. What is the purpose of investigation? Facts has to be derived. In the cybercrime situation, to deriving the facts as an enforcement officer or as a judicial officer, who is going to give you the components? I am sure that not the law enforcement officers. They are not the expert. Here we need the help of cyber forensic, who can create the electronic evidence. The sections I am going to provide. Section 65 of the IPC, Indian Penal Code. 65A, B, 1, 2, 3, 4. There I can already say that it is a mandatory that I can take this as electronic evidence. Nuances is very much there. But who is going to put forth the evidence? The expert. The processing. The device will have the device system will have the data, will have the ingredients, will have the documents. But unless it is retrieved, unless it is made into processing, if your processor does not permit you to process hard copy, how can you have the finalized investigation report? I know that this is an electronic evidence, but unless I put forth that, how to do that? Now, if you look at the section, if you look at the IT Act, if you look at the IPC, like Bharatiya Nyaya Samhita, you will find that a very much amended portion of those Act is very much there, how to protect the electronic evidence, how to produce the electronic evidence. They are very much standard operative system is very much indicated as due diligence, so like that. I'm going to discuss that. So this is very much there. Now I am in my PowerPoint presentation, I am just giving you the framework. My dear friend, when you get hold of this, try to browse in the system and get the details. Then you will understand what is the purpose of presentation. Now there, when I talk about digital evidence, as of today, there need to be certification. Now, what is certification? Certification means I am an organization, I am a fiduciary or an individual data, personal data. So I am having a protective measures. Clear? Now, what has happened is this data has been stolen by somebody. How to establish whether the fiduciaries has sold the data for their commercial activity or it has been stolen and in form of malware or spyware or trojans? It's very difficult. Who is going to give that? The forensic, cyber forensic, the forensic expert? The law enforcement officer is not expected to know, or the judiciary is not expected to know the forensic activity of electronic evidence unless it is retrieved. So the organization, when you are going to take over the devices as a law enforcement officer in the search list or in the inventory list. The actual person who is handling the computer system or the digital system or the cyberspace need to certify certain areas, and that is very much incorporated in the regulations and rules. And unless that certification is very much there, the final investigation or final judgment or adjudication will never come up. So that nuances has to be there in the matter of investigation of cybercrime offences. Of late, this matter has been taken up in the Supreme Court. I'll show you the citation. I don't remember the citation. What they have said, in absence of the certification, sometime what happened, the people refuse to give certificate or whatever, during the activity of search and all. Then does the investigator suffer? Does the law enforcement activity suffer? No. The Supreme Court has said, if the devices are not in possession of the party or the accused, the certification may not be a part played as important. Then the adjudicator or the petitioner, what they have to do is, they have to create some method by which the certification will be made available even after charge sheet. That is very much there in the Supreme Court judgment. So that means that they have understood the problem in the electronic evidence, and they have interpreted in a different way and given a sort of windows of opportunity to the law enforcement so that the criminals does not get scot-free. Try to understand this. So these are the points which I am trying to suggest. I am suggesting before my participants, get hold of these activities, get hold of these case studies. Simply by word of the sections, simply by the enactments, it will not have a fulfillment of your activity. Try to understand this. And that is why I find, particularly in the cybercrime, the judiciary plays the most important play in the system, particularly in India. This we are going to discuss in the next one. Actually, particular sections are there. Now, section 66A, B, 66A, B, C, all these things are there. Section 43 of the IT Act, that's very important. Now, let me share one more thing, that the contraventions of the IT Act, contraventions of the CRPC or whatever, in certain portions, we take it as a criminal law. That means under CRPC, procedure under CRPC. But at the same time, we take it as a civil proceedings, like compensation, consent, illegal activity. These are, not for any profitability. So this can go as a compensatory area in a civil law, civil proceedings. At the same time, the proceedings can be initiated as a criminal proceeding. This will not be taken as a double jeopardy. These are very much there. Now, one of the most important, I don't know whether I'll get time or not, most important area, Shreya Singhal case. That's very important play. That means the person's knowledge. That means the fundamental right of section, I think constitutional right of freedom of expression and freedom, that is very much discussed in that particular case. I'll show you that citation also. Section 43, unauthorized access and damage to the computer system of data or data. 66, these are sections, it is available in your books and all. You can just have a cursory look up this slide. This last section 17.8 and 18, powers conferred to officers for investigating cyber offences. Now here, the power so far has been vested to the Inspector of Police, not below the rank of Inspector of Police. And at the same time, power of police officer to enter, search and arrest without warrant in certain cybercrime cases. Here, the FIR system is very much there, and how to finalize the FIR, there is a portal. India has created, we have created a portal that once the victim submits this sort of information to the portal, will be taken as an FIR. That is the change. Otherwise, in other enactments of the crimes, FIR needs to be presented before the police station by the victims or by whoever wants to make the FIR. These are actually cheating, these are actually, it was, my presentation was Indian Penal Code, but now I have changed it to BNS. These are actually BNS sections. You will find last section is intimidation, threats, harassment through digital means. This is very much active, particularly in our administrative workings. You will find, now what has happened? Now one simple question I'll tell you. Now you will find at a nursery school, you will find there are certain CCTVs installed. I just give you a very practical example. A nursery boy is going in the education system of the country. They have to be, drafted in the CCTV system. Why? Because it's a protective measure of the organizers, so that the parents cannot make any complaint that my child has been mishandled. It's a sort of protective measures. So digital system has given you this protective measures as on today, but it was not there early. If you look at in present, what you call syllabus of our country, like CBSE or ICSE or whatever, you will find the system is very much analyzed that no teachers can beat a person, no teacher can have a harshly attitude to his boys or students. Now, it's a sort of protective measures of the administration or the organizers, and that is very much there because of what? Because of this section 351, 1, 2, 3, 4, intimation. I don't like this organizer. I don't like this school. They are having a commercial importance. So to circumvent the commercial importance of that organization, there could be some wrong communication. There could be some activities of harassment or digital, what you call, under digital means. So just to protect that, organizers are putting the CCTV. If I say, am I wrong? No. So these are actually is very much important when you have a research on this particular crimes of the world. This slide is very important. Don't forget this slide, because slide could not give you the details of these regulations and rules. But I am just trying to project these slides so that you can have a details in the books and system or in the digital, internet or whatever. Now here, I have certain developments on this slide. You see, I'll just read out some portions of the details. National Cyber Security Policy 2023. The objective of this policy is to safeguard both information and the infrastructure of cyberspace. It seeks to establish the capabilities needed to prevent and respond effectively to cyber threats, as well as to minimize vulnerabilities and mitigate the impact of cyber incidents. These are the concept of this policy. Now, every policy has been determined by looking at the different modus operandi of the crimes. How to protect them. And this is the regulations and rules, and the policy and the guidelines have been created. Information Technology Guidelines for Intermediaries and Digital Media Ethics Rules 2021. India implemented regulations commonly referred to as an intermediary rules. These, why intermediary rules? Because we are yet to formulate the Indian Digital Act. All these activities will be made into one act that is called probably. This is the suggestion which is being discussed even with the experts and all. So Indian Digital Act, that will be only one act where all these activities will be earmarked and put into one place so that it will be easier for everybody to implement or to administer. DPDPA is an act that provides for the possession of digital personal data in a manner that recognizes both the right of individuals to protect their personal data and the need to process such personal data for lawful purposes. It has a clear mandate for reporting incidents and fines for not following the mandate. You will find that under the Data Protection Act, there has been a formulation that who will adjudicate. The adjudicator is the data projecting officer or something like the DPO or what you call. I'll come up later on. The designation is like that, and that one personnel will be earmarked who is going to adjudicate. Now, the process of adjudication, you are all aware that there should be charge sheet or show cause notice, then there should be hearing, then there should be what you call trial, and then conviction or whatever, passing of judgment. Now here, in the cybercrime situation, the adjudicator is particularly a civil man. Now the civil man is going to adjudicate. Why? Because there is a point of compensation. There is a point of regulatory activity of the data owner. That means personal data owner who has created the data. Let me share you one more point before I proceed further. What is digital data? Section 2, subsection 8 of the Digital Protection Act. Data means a representation of information, facts, concepts, opinions, or instructions in a manner suitable for communication, interpretation, or processing by human being or by a automated means. That means I have created this data after doing my research analysis for development of a electrical infrastructure project. It is stored in the cloud store. Okay. Now that has been robbed. That data has been robbed. What happened? I lose quite substantial amount. Mind it, my architect has prepared the system architect, he has prepared the data for me. And I am the owner of this data. If my personal data are not protected, I lose commercially, huge amount. If you look at the penal portion of these crimes, the penalty could raise up to 250 crores. You can't imagine. Or 10% of the organization's profit. An organization, they are the fiduciaries. They have not created the data. They are the owner of the data. They have spent, the research people has made this data. And the organization fiduciary, he has taken the consent of the individuals who has created the data. And fiduciary is going to make money commercial importance when they utilize the data. Now what happened is, fiduciary has got certain, once I give the consent, the individual owner of the personal data, he has given the consent to the fiduciaries, maybe selling or whatever, and the consent has got certain conditions. Like condition, you can't share the data, or you cannot sell the data, whatever. As per the requirement or the agreement. The consent letter has given all these conditions. And now the fiduciaries have not properly activated or fulfilled the conditions. Who is at a loss? The individual data owner. His data has been wrongly utilized. The consent does not indicate. And you will find in the regulation, in the act itself, what is called consent. What is the preamble of the consent? And how to activate, what could be the conditions of the consent? Now you being the interpreter of the law, if you do not see the conditions in the consent agreement, then you cannot finalize as an adjudicator. Try to understand this. So these are the points is very much there in the cyberspace. So this is what I am trying to say, that when we have the conditions laid down in the consent, if the consents are not fulfilled or agreed upon, then automatically the individual has got the right to withdraw his consent. It's not 1 rupee, 2 rupees matter. It's $1 million question. Commercial importance is 1,000 crores. So the Act said that if such activity is identified, the adjudicator can impose a sort in the civil matters. I'm not talking about criminal matters. The adjudicator is called as something like that. What is his name? 4. Chapter 6 of this Data Protection Act. Powers, functions and procedure to be followed by the data Protection Board. Data Protection Board, DPB. The responsibility of DPB is very much there indicated in the Act. And DPB, once they find, I am talking about civil proceedings, I am not talking about criminal proceedings. Under the civil proceedings, the data board can impose a sort of compensation amounting to maybe 10% of the profit margin of the organization. Say a Reliance Corporation, their actually finance data is quite high. So if the board imposes 250 crores, is just a very small amount for them, because they have misutilized the data, and by which the protective measures of the data, personal data owner has been lost. So these are the areas which needs to be more researched upon. And at the same time, the data board, while imposing the penalty, a sort of compensation amount, they can, the section 43 of the IT Act, there are two approaches. It can go also in the criminal proceedings, by which the imprisonment up to 7 years can reach. So, same case, similar type of thing, one is civil proceeding under obligation, non-fulfillment of obligation as made by the data board, found by the data board and as an adjudicator, compensation, and at the same time punishment in the court of law under CRPC. This is available under this particular fraud. Now these are, I was talking about this particular area. Now one more important area I must say. Companies Management and Administration Rules 2014 requires companies to ensure that electronic records and systems are secured from unauthorized access and tampering. Now mind it, a company, a fiduciary, he has actually purchased or have the consent of the data, personal data individuals. And consent has been given with certain conditions. Now in the matter of investigation, the fiduciary has to fulfill and show that he has fulfilled the conditions, he has not violated the condition. How? He should have certain conditions, some responsibilities, here not. And those responsibilities mind it, he may not utilize the data. Reliance Corporation is such a huge company. I'm just giving you an example. They might have utilized this data with some of their other personnel, other companies, shared, and that is very much there in the consent. Now the responsibility of the fiduciary is connected with the data owner. Now fiduciary is going to share his data for development of his working or infrastructure. Now what is and he becomes an intermediary, mind it. So what is the responsibility of the intermediary? It was not there earlier. It was just been created on 2021. And what is the intermediary's condition? Let me tell you, share some of the conditions. We're right on time? Or any? Okay? Okay. What are the liabilities? Under Section 79 of the Information Technology Act, the intermediary is required to comply with due diligence. Standards prescribed by the government, the Information in Technology Intermediary Guidelines Rules 2011 elaborates the due diligence to be observed by the intermediary. The intermediary is required to place a privacy policy and user agreement before allowing access to its platform to any person for disseminating the information. So this is the intermediary. I am the owner. I have sold it to X organization. He becomes a fiduciary. And fiduciaries are developing the data with intermediaries. What is the intermediary's responsibility? That was not there earlier. And it was made available very recently. And mind it, I'll just read out certain of the conditions. And you will find it is labeled to 1.5 page conditions. But if the law has said that these are the conditions of the intermediaries, then definitely in the parliament, what they are discussing, that is a wrong place, wrong way, I should say. Why? Because it has been very much there in the Data Protection Act that what is the responsibility of the fiduciaries, what fiduciaries should do, what risk they should minimize. That is there in the Act. But in the rules, I am trying to fulfill these points. I do not know why, unfortunately, in certain parliamentarian is delaying the process. I am sorry to tell you. As an academician, I am telling you. I am not a political man. Why delaying? Once you delay it, that means in whole India we are losing. Why enactment? Why conviction? Tell me, why we try to put a person in the jail? We don't call it as a jail. What do we call it? Is it? क्या बोलता है उसको? Mind change करने के लिए. What is the in the jail का क्या नाम है? Correction. Is it?
Correction. Reformative.
बोलिए.
Correction.
What is it?
Correction.
Correction. Yes, right. Corrective measures. That means I am putting you inside the bar to correct yourself. So, if I put forth 1, 2, 3, 4 responsibility as a fiduciary or responsibility as an intermediaries, it's a sort of establishment of the sections of the law, so that the implementation and the involvement of the sections of the law could be fulfilled properly. It's unfortunate. Now, let me share due diligence to be observed by intermediary. The intermediary shall observe. These are the conditions. Shall observe, number 1, intermediary shall publish the rules and regulations, privacy policy and user agreement for access or usage of the intermediary's computer resource by any person. Now, intermediary is a sort of administrator. He is utilizing his computer architects to work on it. If the computer architect plays a wrong way and do some mischievous activity, it should be clearly embodied in their functioning as an employee and employer. Mind it. I, being a computer expert, working under a certain fiduciary or certain intermediary, if I do some mischief, then there should be some responsibility in black and white that what is his responsibility. And that responsibility, that means he has to have some sort of agreement with his worker that he is not going to sell or he is not going to divulge to other persons other than his companies. Mind it, though As on today, you will find internationally there are certain security measures available in the data portions. Like in my computer, I can put some sort of security measures so that this cannot be passed on to third person. But still then, it should be black and white as the responsibility. And that is very much there. And that rules which you are going to process, which you are going to enact, they are particularly, I have seen that 1, 2, 3, 4 conditions are laid down under the rules, the fiduciary's rules and intermediaries' rules. Clear? Like that, see, is grossly, belongs to another person who is, now, he is an intermediary. So he should see that the individual is not at a loss. That means the data owner is not at a loss. That is very much there. Is grossly harmful, harassing, defamatory, obscene, pornographic, all these things has to be laid down in the conditions of the intermediary or fiduciaries. That is there. Like that, it is one, not only one or two, it is a huge. Intermediary shall take all reasonable resources. This is one more highlighting. Intermediary shall take all reasonable measures to secure its computer resource and information contained therein, following the reasonable security practices and procedures as prescribed in the Information Technology Reasonable Security Practices and Procedures, Sensitive Personal Information Rules 2011. That means when he is going to have a sort of engagement of his worker or his employee, he should have these points agreed upon by even with the employee and employer, so that he could not be made responsible with the data owner and the data fiduciaries. Mind it. So these are the risk management one has to develop. Intermediary shall publish on its website the name of the grievance officer and his contact details, as well as mechanism by which user or any victim who suffers as a result of access or usage of computer resource by any person in violation of his agreement. The grievance officer shall redress the complaints within 1 month from the date of receipt of the complaint. Now these are the conditions laid down to what is the aim, what is the target? Protection of data. Protective measures of the data. My personal data is not going to be misutilized or misrepresented or beyond the capacity of the agreement on consent. Clear? Now these are the points. Like any other thing I can. This one more important one is that establishment of National Critical Information Infrastructure Protection Center, NCIIPC. NCIIPC. Establishment of National Critical Information Infrastructure Protection Center. That means a complaint has to be lodged either to the this actually under the policy, the complaint needs to be lodged that either computer emergency response team or to NCIIPC immediately within certain period or specified period of time. In case the data, this is the measures which has been laid down on the policy to safeguard the responsibilities of the individuals, fiduciaries or intermediaries. These are the policy decisions has been made. So when we talk about holding the responsibility, the quantum of responsibility, quantum of risk measures, anti-risk measures adopted by the people, by the user of the data. These conditions are very much important. And this has been taken from international, areas, like what European Union is doing, what US are doing, like that we have shared those points and put into the policy. Like if you feel, if you find another one is that in 2021, India implemented regulations, intermediaries rules. Government is presently examining to replace IT Act with the Digital India Act, which will deal online safety, trust, accountability under new article of international technologies, etc., etc. Like that. So, taking cue from the international techniques of the cybercrime operations, we are trying to create a sort of one system that is called Indian Digital Act. This is just in a very premier stage, not in actually, it is some discussion, but I am just sharing you because definitely it will come up very soon. I was talking about that one of most important area where the central government has issued, that is called tools like mobile Kavach. Tools like mobile Kavach, that is not there in my slide. Kavach. So mobile Kavach to address mobile threats. So that is also there very much indicated in the government area. So that is the last one. And when I say about TRI recommendation 2018, they have certain areas which they have indicated. One of the important area to communicate is that as I have said, that adjudication, the decision given by the data protection officer constituted under Data Protection Act and rules is yet to be formulated. So once they sort of adjudicate and give an order, as an adjudicator, the flow chart is that once I give a decision, the principle of natural justice demands that I should have a right to make an appeal. So here, the appeal will lie not on the constituted body because rules are yet to be formulated, but at present it led to that what we call TDA Appellate Tribunal, that means Telecommunication Appellate Tribunal. They are actually concerned in telecommunication disputes and all, but here on the database so long it is not constituted because decisions are very much there by DOB, and I said that it is both a civil as well as criminal. Criminal will be taken care by the judiciary, but what about civil activity, civil adjudication? That will lie to the appellate forum, is that TRI appellate forum, okay? So, this slide I'll just skip up, okay? Now there are actually certain bilateral treaties and this. One of the foremost, I should not say foremost, the first treaty of under cyber crime is that is the treaty that is called Budapest Treaty, Budapest Convention. But India, being a participant of the Budapest Convention, we have not ratified the convention because of one issue, that it has not fulfilled or it has not established any point of reversion and put our constitution upheld. Mind it, there has been as you know that under constitutional right, I have a privacy. I have certain fundamental rights. That has not been projected in the Budapest Convention. And that is why we have not ratified that. Then, what to do? Bilateral treaties we have made. I'll just tell you. We have made certain bilateral treaties with different countries. Bilateral treaties with nations like Bangladesh, Bhutan, Nepal and Sri Lanka. In 2022, international cooperation with India and UK. Substantial talk has been made on cyberspace. Then India-France Cyber Dialogue 2021. 8th meeting of the BRICS in 2022. Use of information and communication technology on virtual mode. These has been established. Then 6th India-Germany Cyber Dialogue on 2022 at Bonn. That is, they talked about cyber security. How to secure your data, how to secure the cyber menace has to combat, how to combat this. These are there. Now key object, and then basic is, I told you the Budapest Convention, all the agendas are very much important, but why you have not ratified is because of that reason that it has, say certain country, certain unfriendly country wants to do some mischievous activity. That protective measure or that sort of conditions was not available in the Budapest Convention. Because if any unfriendly country wants to take some measures against India, that has not been conditioned in the Budapest Convention. That is why we have not ratified. But we have made a lot of institutional efforts to create a sort of treaties against this cyberspace menaces. Okay? And that is what is there. And United Nations General Assembly, as you know, 190, they are, mind it, we have a projection, as you are aware, that we have one treaty was there, that is more or less economic offenders. There we could, if certain offender, like you know, lot of economic offenders who have actually left the country illegally and all, we want to put them behind the bar in India. So there should be some sort of convention to create. So we, under that economic bilateral treaties, we could put the cybercrime perpetrators to bring back to India. Like that, so far. Because absolute established international convention on cyberspace yet to be formalized. That is the thing. Okay. This key objectives of UN Convention on Cybercrime, it is very much there under UN Convention, but particularly in place of Budapest Convention, which is exclusively for cyberspace, is yet to be formulated. That is the thing. These are the two, so far, two treaties we have made, signed treaty, ratified treaties. That is, one is India signed MOU with Germany and India with Malaysia, Singapore and Japan. These are the two particular treaties we have made. So that's all about this. Conclusion, we have been discussing in the entire session. In the face of rapidly evolving cyber threats, India has developed a multi-layered legal, regulatory and institutional framework to combat cybercrime. The convergence of IT Act, as I told you, and Bharatiya Nyaya Samhita, we definitely request one particular specific act to combat the situation. And a well-informed now, one more important thing, I should very much surrender that unless we are forensic expert, the investigation cannot be made as per the statute, as per the law of the country, as per the principle of natural justice. I can very well make a comments on that because I need one particular act, because if suppose 66A, freedom of expression, okay, I agree that fundamental right is the super, but at the same time I have to create a sort of substantive regulations to combat, say for health ground, from health reason. Now, prenatal conditions, as you know. Now there are so many hospitals, they are making an advertisement of illegal means. I mean, illegality in the sense of acts, but not illegality in the sense of scientific doctor's formula. But those are the areas we have to have some specific importance, specific law, specific rules for that. Because here, I've got a data. The country where we are saying in India, we have our own requirements. But that requirement cannot be at par with other developed countries. Now, in the globalization process, lot of international research people, internationally organized hospitals are coming up to India. They have their own profiling of advertisement, which is there as per the law of that country, original country. But in our country, that advertisement restricts under certain regulations. Whether that advertisement in the cyberspace, in the multimedia communication is approved under the law or not. That is the point to be made known. It is my just own point of view, so you can think of that. Because my dear participants are more a sort of adjudicator. I am not, probably most of you are not the field officers. So when you judge a thing, when you analyze the rationality of the conviction, automatically these points are very much important. So that's all this session. Next. Any question? I mean, I cannot answer all your questions. Probably I am not that much equipped. Let me frankly tell you. But I can very well say, very well answer your questions as per the present position of the situations. More activity. It needs more research. More research. See, exactly Budapest Convention में जो wording था, it lacks, I'll tell you, I have seen the agenda, it lacks specific safeguards for basic human rights and includes broad language that is ripe for abuse by authoritative government. India did not ratify this. Authoritative country means any, country which is not there. Okay. Now session 2. Okay. Now this is actually Digital Personal Data Protection Act. Now when we talk about Digital Personal Data Protection Act, what is data? We have already said as per the Act, but let me see what is information under the RTI Act. RTI Act, information of private body which can be accessed by public body as per any other law for the time being in force. Now there, mind it, this is the only salient area of change. RTI Act, information of private body which can be accessed by public body as per any other laws of the country as on, any other law for the time being in force. That means if any other law barred you to communicate this information, you are not in a position to communicate. Number one. Number two is that under Information Act, there is no point where I can delete, where I can make a sort of change in my information. But in this particular Data Development Act, there is a system of sharing these data. These are certain changes under Information Act and this data. Now here we have three categories what we are discussing. Number one is individual who has created the data, who has made the research, spent money towards this, and number two, who are actually the individuals have shared this data for their either commercial importance or whatever, and then the fiduciary, the middleman, fiduciary who are going to use this data for commercial purpose. They might utilize the intermediary. So there are 3 points. One is individual, another is fiduciary, next is intermediaries. These are, and their fulfillment and conditions have been there in the Data Act. But once the rules not formulated, you cannot have proper implementation of the Act. That is one thing. Comprehensive legislation in India aims of safeguarding personal data in the increasing digitalized world. The Act aimed to ensure privacy rights while enabling technological and economic growth. That is important, and that is the aim of this particular Act. I have discussed the data principle and data fiduciaries, and their key points have been area. I'll just, exemptions of course are there. Exemptions are for small businesses, small time operators. They don't have to fulfill this Act. Number one, exemptions are there, and government agencies are exempt from purposes related to national security, law enforcement and delivery of public service. Now, what is the example of delivery of public service? Say, delivery of public service means that suppose health ground. We like to make some advertisement on health ground. No matter whether this is a data which has been taken from some individuals or something, but that is exempted of these protective measures. When government, let us talk about EDI, electronic data interchange. Which system, like you, the judiciary, as you are also approaching towards what you call digitalized communication, digitalized, securing your data of conviction, securing the analytic points of the convicts, the identifications of the convicts, say for instance, can you at the time, once he is convicted, before conviction, as a law enforcing officer, once I arrest a person, can I project his picture in the newspaper, advertise it? No, unless court permits. So court is going to permit when? For the purpose of Indian development, for the purpose of exemption category. Say for a person who is, absconding. I'm sorry. Hello? পরে বলবেন। This is the interruption. That is why people say that you switch off the mobile. I am actually outstation, so naturally I don't like to switch off. Maybe certain important fine point will come. Anyway, where you were? Yes, absconding persons. Now, once you declared a person as absconding, you are free to put his picture in the newspaper. So, this is very much there in the Constitution. But once a person is arrested, can I put his name that he is a smuggler, so he is like that? No. So, these are the areas of exemptions. I am putting his name in the advertisement. So that is under the exemption category of this. For example's sake, I am telling you, it may be hundreds of examples. But am I able to inform my points? Okay? Any question on this? Because I am not satisfied with the answer, very frankly tell you, because of disruption. Anyway, then this important sections, I'll tell you, DPBI is the key regulatory authority. Data Protection Board of India. I told you during discussion that DPB has got the very important role under this act. So this needs to be constituted under the rules. So that they are the most important regulatory body which needs to be placed once the rules are there. Now DPBI, one of the responsibility is being addressed is data breach. I told you the agreement or consent, certain conditions. Now once the condition is breached, who is going to give a protection to the individual who is this thing? DPBI. They are going to put forth the place the points before the perpetrators or the victims that this is the area where you can make an appeal or make a sort of compensation. Like this is important one. And then data, let me skip up this slide, next slide. Okay, you will find next slide, this is there. Now what is the main purpose? There are certain points. Now these are the major points. Lawful and transparent. Number one, purpose of limitation. Data minimization. What do you mean by data minimization? Now, I was telling you that under, let me tell you. This our, Aadhaar card. Now Aadhaar card, there is a confusion, as you know, in the media. We all know about that confusion. Now once I put a sort of data for making a sort of Aadhaar card. Now data are available with the authority who has made the data final. Who has given the Aadhaar card. Now this Aadhaar card, once it is placed, now can it be utilized for any other purpose? What is the condition of utilization? Say for instance, Aadhaar card is prepared by X. I have my individual data like my name, address, eyeball, so and so, so and so, so and so, all the points. Now these points is my own data, personal data. Now the person who is giving the Aadhaar card, is there a balance made between the Aadhaar card situation and the Data Protection Act? Point what I am trying to make it, you have understood the point? Now let me share one more important regulation, then it will be made clear. Just a minute. Data privacy under RTI Act. Right to privacy is available even to a woman of his university. Public's right must prevail over the privacy of the third party. There has been a judgment. 8(1)(j) of the Information Act does not make any distinction between private person and public authority. There are certain judgments of Supreme Court. You can get it from this thing. Now here, what I was discussing is that this Aadhaar card, there is a regulation of Aadhaar card. Let me share that regulation. Because it was a point raised in the Parliament of India that whether the data put forth for getting the Aadhaar card, is there any balance made under this Protection Act? Because here in the Protection Act, there is a consent, there is a minimization of data, there is a change of data, there are so many, and I cannot share these data unless I consent it. Now once I have an Aadhaar card, like when I am going to the hotel people wanted my Aadhaar card. I have shared the Aadhaar card to the hotel people. Under what law? Suppose somebody does not share the Aadhaar card to him. Will that point be raised that the balance has not been established about the personal data protection and the data put forth in the Aadhaar card? Am I able to clear you? Now this is a point which I raise because my level of participants, what I was told is mostly judicial officers. So I am just trying to give a point to my dear participants that whether asking for the Aadhaar card while going inside the hotel will create a sort of controversy on Right to Information Act vis-a-vis Data Protection Act vis-a-vis that regulation. I mean Aadhaar card regulation, there is a regulation. I have the name, but I'll just share that name afterwards. There is a regulation of Aadhaar card. So that regulation, this Protection Act and this Information Act, whether balance is created. If there is balance, okay. Any other law for the time being in force. But sharing my data to the hotel management, will it establish a controversy against this act or not? I am very, very clear on this. Because I am trying to cater, trying to establish my research point before my dear participants. Okay. Now here accountability is very important. Once I am sharing the data to the election commissioners, there is accountability. Once I share this data to XYZ, accountability is there because consent will see the agreement. There is responsibility established under the statute about the intermediaries, user and all these things of data. So accountability is there. Once I give the data to the bank for opening my savings bank account, whether these data can be shared by the bank to other agency? No. No. Unless any other law for the time being enforced and exemption category hoga ki nahi. You know, I'll just tell you one example because I worked so many years in the department. Before that, when I used to send my investigator to the bank used to say, hey, these are confidential matters of accounts, I am not going to share with you. Because investigation wanted this level of understanding of bank account statement. So bank refused to give us. I remember the incident. My IO came and told me that look, the bank is, I'm talking about 80s and 90s, mind it. Just to give you my communication rightly, I am just sharing this. Now my IO came and said, sir, that bank is refusing to give the statement of account of that particular person, of that particular organization. Then I said, why? Then the IO said that, sir, they have showed me the bank, Reserve Bank policy and all these things, and they are protected. They cannot share. I thought of it. What I said is, I instructed the IO, you issue a summon. Because it's available under Customs Act. You issue a summon, and in the summon you indicate, please produce the account statement of Mr. So-and-so held at your bank. And summon under section so-and-so of the Customs 108 or so-and-so is available. So I direct you to produce these data. You have to produce. So once I get the summon, once summons are issued to the bank manager gave me a ring. ये साहब क्या करेगा? हम बोले साहब ऐसा करो, आप दे दो, नहीं देगा तो 193 IPC में आप पड़ जाएगा. Don't say no, say yes. So immediately they gave. What I was telling you, that in those days the RBI regulation was never indicated that it is to be shared. Now here the Data Protection Act has got certain regulations, and that regulation is yet to be finalized. So sharing of my other data, once I put forth to the bank for opening of my savings account, can the bank people share with the third party? As on today, no, unless I give consent. So these are the areas which needs to have a balanced attitude, balancing the thing. Okay. Now security safeguard, these are all are the legal principles. But details, I told you, in the Act is promulgated. Unless the rules are established under the law, we cannot enforce it properly. So what are the factors of being lawful and transparent? That will be available in the rules. Consent-based data processing. Data collection must be based on clear, informed, explicit consent. Explicit consent. What does it mean, explicit consent? We have been discussing in the first session also. Individuals have the right to withdraw consent anytime. Companies must make the process of consent withdrawal simple and accessible. Now here, if you are organized, data user, you have to have a responsible officer constituted who will be as a data protector of that user. That is available under this law. Processing without consent, that is what I told you, national security, public interest, government mandated, disaster management, law enforcement, investigation, EDI and other things, all are exempted. Individual's right. I have created the data, what is my rights? That is their right to access. Now, once I am an individual, having the right to know how their personal data is being processed and for what purpose. I put forth a data to get the Aadhaar card, and that Aadhaar card, unless I share it, I give the consent, you can't share it. A bank people, every bank people wanted the Aadhaar card and other things, Xerox copy of the PAN and all these things. So once the data are my personal data, you are sharing only for the purpose of there, and that is available on the RBI manual. But if you want to share with third party, you need my consent. I am an individual. That's my data. Okay? Right to grievance redressal, I am discussing Data Protection Board. Their responsibility is very, very high. And once the rules are formulated, the responsibility of data board will be formalized. Right to nominate. Now I have my own data. I can just nominee, as a nominee I can put that data on my son's name. Because data are data, and that is costing multi-million dollar. That's a property as per the law. So once my property is there, I can always nominate. So under this law, the nomination is there. Then once I give the consent, I am the individual owner of the data. I have right to withdraw the consent. It's not the consent, conditional consent, mind it, as per the law. Obtain explicit consent, ensure data minimization, maintain accuracy and security, report data breaches promptly, maintain transparency, ensure accountability and compliance. And I told you that individual fiduciaries or organizations need to have a earmarked identified person as then they are called as a data protection officer, DPO. Why? Because suppose I am an individual, I like to communicate whether there is any breaches or not. Suppose this government organization have got certain FIR, certain information from certain complaint. And they found the data is individually so and so. So that particular part is very much placed in the Act. Accountability and compliance. The Act allows cross-border transfer of personal data to countries approved by Union government. Now here, export of data. Export of data is available provided the government permits it. As you know, there is a foreign trade policy in every country. We have our own foreign trade policy. Whether these data could be exported out of the country or not, that depends on the foreign trade policy. If the foreign trade policy does not permit sharing the data to individual of US, I don't name the country, any country. So unless it is allowed under the foreign trade policy, trade negotiation with that country and this country is available, you cannot share the data. That's very much important. Because sharing of data is very important. You know, of the place, if I tell you that India is earning huge amount of foreign exchange, by exporting this type of infrastructural data, particularly to the Middle East countries, officially. And we are earning thousand crores of foreign exchange by exporting the data. By exporting, and data means infrastructural development. Oil project, ONGC is exporting their data to other country for exploration of oil, high seas oil. So these are available under the foreign trade policy, but it needs to be at par with the subsidiary or the other acts of the country. Sensitive data consideration, sensitive data health. I have been telling you the examples, sensitive biometric or health grounds, advertisement and all these things, the data. You cannot do that unless there is a government no objection. Available as per the laws available on the country. Parental consent. Processing personal data of individuals under 18 years, verifiable consent from a parent or legal. These are actually as per the consent agreement and all these things. Let me not share this. No harm principle, data processing must not cause detrimental effect, well-being of the children, prohibition of targeting, tracking, profiling, behavior, safe digital experience. These are mostly for media. For medias, these data they share or they don't share like that. Now, I told you the fines and penalties up to 250 crores. That is available there. And TDSAT, actually I was forgetting this name because of my old age. Telecom Dispute Settlement and Appellate Tribunal. Okay? Sorry. Positive impact. Now, DPBI, Data Protective, I'll tell you, DPBI, Impact Assessment. Data Protective Impact Assessment, DPIA, Data Protection Impact Assessment, help organizations identify and minimize risk to data subjects' rights, freedom of data processing activities. It mandates high-risk processing activity. For specific examples such as activities are a good place to look, that is rights of freedom of natural pursuit. Why conduct DPIA? Now these are data processing impact assessment. That means I am processing this data. I am a fiduciary. Now for individual this is not very important. It is important because I must know that they have a impact assessment. As a protective measure of my own data. I am the owner of the data. So DPIA assessment has to be made by the user, by the fiduciaries. And as per the Act, this is exempted to the small category of people, organization. But for the organized sector, once they share the data from the individual as a fiduciary, they have responsibility of impact assessment done by their own organization. If the impact assessment indicate that sharing or using these data will attract wrong usage of data or misuse of data, this responsibility has to be projected by the person as fiduciary using my data. Am I clear to you? This is, as on today, this is available on the organized sector. As per the rules which is drafted today, which is drafted and yet to be formalized, there the indications are there. It is available. It is projected only for organized fiduciaries, like big firms, big companies and all, who are normally sharing their data to other intermediaries who are also very high up, not for individual normal thing. So this is available. And what is the assessment condition? I have written up that one. Just a minute. DPIA, one more thing, DPIA is important and useful way of ensuring the efficiency and cost effectiveness of the security measures you implement. A risk-based approach ensures you do not waste the resources attempting to mitigate threats that are unlikely to occur or will have little effect. Not carrying out DPIA when required could leave you open to enforcement action, and this might indicate 2% penalty on the organization. So DPIA is a sort of protective measure of the user of my data. Because this is available, say fiduciary is a very organized sector. Now one organized sector is sharing sharing his data as an intermediary who are also organized sector. Now these data, the consent was given for utilization of development of say electrical project. Now this intermediary who were sharing these data for the purpose of other project, for which the consent agreement does not indicate. I am an individual. I have passed an agreement consent. One fiduciary, he has using my data. I have shared him agreement. This fiduciary organized, they are linked with individual and the fiduciary organization. This organization is sharing to second man, third man, fourth man. So when they are sharing, the consent indicated that this data should be utilized for this purpose. And you will have no authority to minimize this data, to develop this data, or to oblige the data. That is there in the agreement and consent. But the third party, they have misutilized that. Who is going to indicate that? DPIA. The data protection assessment. So intermediary or the fiduciary needs to have DPIA done. Self-assessment. That means I myself, organized sector, I have this assessment. So if he has breached the data, that is his responsibility, not mine. So DPIA assessment report for the purpose of misusing or breach against, contravention is very much important while judging the breach. What is the consent? Whether he has breached. Breach means what? I have given the data for the purpose of X. And the third intermediary has violated the consent, breached the data, minimized the data, developed the data, changed the data. It happens. Say my research paper indicated that this component required for anti-cancer tablets. Say, I have a chemical. That chemical, my research paper shows, is being developed for the purpose of cancer treatment. I have shared this data to the intermediaries who is utilizing my data for the purpose of development of anti-oxidization tablet. The consent does not permit you to utilize my data for the purpose of this. So you have breached the data. Am I clear to you? So this has to be assessed by whom? By the fiduciaries or by the person, third person or fourth person who is sharing to other intermediaries. It is a protective measure for the individuals who have no access to the third intermediaries. But he is going to make a complaint that my data which I have shared to the fiduciary, he has breached. So fiduciary has to put forth his responsibility by indicating that, look, my DPIA assessment. Because I have this architects, he has sent this data to X and for the purpose of this. So I have not breached. He has breached. So this is the purpose of conviction or the penalization. Clear? Okay. DPB, I have time now? Okay. Is a landmark step in India's data privacy and protection framework, strikes a balance between individual rights, business growth and national security. The Act's success depends on effective implementation, awareness and regulatory enforcement. Businesses must adopt privacy-first policies to ensure smooth compliance. But this is very important because Data Protection Act actually is very important in the sense because once the total globalization of the trade, once the import and exports and the sharing of data are exported, data are huge costly affairs, commercially very important subject. So once the export and import is permitted, if there is any foreign exchange manipulation, if there is any sharing of data to other country, that is, we have to establish this responsibility to X, Y and Z under this investigation reporting. And that statute is very important, and compliance has to be monitored vehemently. Because tomorrow's trade will be only the data export-import, cyberspace import and export, online transfer of money and all. So once the trade, I am talking about domestic trade as well as the international trade, both trade requires to be observed on the situation of globalization of data, import and export. Clear? So next slide, sir. Third. We have in this slide certain case study, and we are going to discuss certain case study. Now case study details, you can, once I am sharing the details of the case study and the arguments and the situations, I suggest that you can just make yourself acquainted after the details of the case. Because the details of the case is available in the system, in the internet, in the media. So you can very well equip yourself, details of argument, details of what is the charges, what is the facts, all these things. I have just projected a small portion of the judgment, okay? Now this slide will indicate, it is very appropriate slide for you, my dear friends and participants, because this is mostly the judiciary's jurisprudence. Shall I just keep up? See, third point, members of the judiciary are increasingly required to interpret complex cybercrime cases involving technical evidence cross-border jurisdictional issues and interpretative challenges under evolving legal frameworks. Because I am happy that my dear participants are mostly adjudicators. So this is very important subject. So please take care of this, because once you identify the balance and changes, it will come up in the law. Try to think of that. Because I was telling you that arrest about judgment of G.K. Vasu. I have just tell you a very small incident where emotionally I was very perturbed. In those days, the foreign gold, क्या बोलते उसको? Foreign Exchange Management Act, Foreign Exchange Regulation Act, Foreign Exchange Regulation Act and Foreign Exchange Management Act. Foreign Exchange Regulation Act 1973, Foreign Exchange Management Act 1999. Now these two acts, once the FEMA is available, FERA has been repealed. Now in the FERA, there is one section that if somebody possesses more than 5 kilos of gold, he has to declare before the agency, before the RBI or whatever. Now in another section, there is an implication that if gold, primary gold and ornaments together is more than 5 kilos, more than something like 500 grams or so, he need not declare. Now here, if you have 5 kg of gold, you have to declare to the agency concerned. Now if you have gold and ornaments, you need not declare. Say section 81 and section 18 subsection 2. Section 18(1) says that if one individual having more than 5 kgs of gold, he needs to declare. The second 18(2) subsection 2 indicated that if you have gold and ornaments, even up to 5 kgs, you need not declare. Okay. So this is the formula. Now what has happened is Caesar was made, and there another definition is what is gold and what is gold article. Gold ornaments definition is there in section 2. Gold article has been declared as sovereigns also gold article. जो गिनी जो बोलता, और primary gold is not gold article, it is gold, primary gold. Am I able to clear you? Now, the judgment. Caesar was made, say, sovereigns weighing 4.5 kgs of gold. Value weighing 4.5 kgs, sovereigns. And Caesar was made for. Now there, under section 18, they said gold. Under section 18(2), they said gold and article, gold and gold article. So once, and they have already seized some ornaments also. And ornaments is article. So if, try to understand this, if I have sovereigns 4.5 kg, ornaments half kg, total 5 kg. So less than 5 kg and less, I need not declare. Because I have articles also. I am not possessing the only gold. I am possessing gold and gold article. But the sections availability is there. If I have single gold, I have more 5 kg is okay. But if I have along with article, I have 5 kg. I need not declare. So Caesar lists indicated that guineas are there and ornaments are there. So while adjudicating process was made, the adjudicator somehow confiscated the gold. These guineas and ornaments he has released. the matter went to High Court. In Madras High Court, the division bench, I have not the citation, the division bench identified this process, that section 18(1) is independent, section 18 subsection 2 is independent. You cannot tag 18(1) and 18(2), and by which the adjudicating order of confiscation of guineas have been released. And in those days, there used to be smuggling of guineas in India. And because of High Court, we actually examined the situations, and the legal remembrancer or whatever you say, that experts, they opine that it is not fit for SLP. Because it's very much clear. So this identification process, this role of judiciary is very important. Another thing I will tell you, I am just quoting your role in the matter, not only on this subject, but role of judiciary is most important. Then when I find that FEMA came up, the entire thing has been deleted. Amended. Then another point, customs can assess and value under valuation rules. Customs officer can value if the goods are any dutiable or prohibited goods can be assessed and valued by the proper officer of customs. This is the indication of sections. Now suppose all imported goods, mostly dutiable and all, okay, value can be done. Export, mostly non-prohibited and non-dutiable. Export, there is no much duty or no prohibition, and very less prohibition. So, in the export, customs has no power to value the goods. If I just argue this point, tell me as an adjudicator, am I right? Let me clear it. Valuation rule says that proper officer will value the goods. And which goods? Which is dutiable or prohibited. If the goods are not dutiable, neither dutiable nor prohibited, what happens? Customs cannot value it. So if there is any misdeclaration in value in export, mostly export valuation is misdeclared in today's situation. People are over-invoicing the export to get availment of incentives. This is the situation of trade. Now, the matter was taken up by the High Court. Because legal matters, law matters, Calcutta High Court decided that, even the division bench decided that yes, customs has no authority to value the export goods. We have projected the FEMA Act, where there is if there is any misdeclaration in value or no, okay, that is added up. But main Customs Act does not indicate the proper officer cannot value it. The matter went to Supreme Court, SLP, because this is a matter of law. Entire export will be customs will lose the power of assessment. Matter went to Supreme Court. Supreme Court kindly decided, taking cue from the FEMA and all, has accepted principally the activity of the Customs Department. Mind it. Indicating that as a violation under FEMA, because of there they said that whatever you are exporting, you are to repatriate the same amount as foreign exchange. Taking argument on that situation, the Supreme Court has accepted principally the customs argument. Clear? Now, let me share my experience. Next time, About a year back, it happened in 2004 or something, and while I was in service in 2001, the case happened. 2004, I have noticed that amendment of Customs Act indicated that the deletion of dutiable and prohibited goods under section 14. Now under section 14 of the Customs Act does not indicate the goods either dutiable or prohibited. It's any goods. Any goods being exported out of country. So deletion of this dutiable or prohibited goods, as a customs man, as a researcher, will definitely assess that this has been part played by the judiciary. And because of judiciary's interpretation, the amendment needs to be done and needed. Am I clear to you? So my dear friend, your interpretation substantially required for the purpose of this cybercrime menace. Mind it, because this is a very latent stage. We are developing the enactments, we are developing the rules and regulations. Your role is very important. That is the preamble of this session. Limited judicial precedent. Cyber jurisprudence is still evolving with relatively few guiding case laws on emerging technologies. Who is going to develop this? You. Digital evidence, that is what I said, that electronic evidence, certification and all these things. Electronic evidence see these three case laws. How digital forensic technique is very important. These four case laws I have cited, these are very exemplary case study where forensic science is very much needed. In Sifu application case, a notorious banking Trojan named Sifu infected numerous computers leading to financial fraud. Law enforcement agencies collaborated with cyber security experts to investigate the case. Though meticulous electronic evidence collection and preservation, including network traffic analysis and forensic examination of infected systems, investigators successfully traced the origins of the malware and identified the perpetrators. So, the use of advanced, this is important, the use of advanced digital forensic techniques and collaboration between law enforcement and technical experts played a crucial role in this investigation. This is very important, and next case is also Delhi University examination scam. You all have seen in the newspaper media and all how the examination scams in Delhi University has been created. They are also from the, they employed forensic imaging and seized key digital evidence such as log files, databases and communication records. The proper handling and preservation of electronic evidence enabled investigators to reconstruct the chain of events and establish the involvement of accused individuals. The importance of digital or electronic evidence is very much important in today's situation. But we or you, being the administrator, being the adjudicator, we lack in this particular area. So what is required is PPP model, public-private model. And that is why we need to have a negotiation or formula of developing ourselves to get an expert while we are going for even at the material time of search and seizure. Mind it. Because you are trying to seize a processor, you are trying to seize a computer disk, you are trying to seize something, electronic evidence, for the purpose of creating an electronic evidence. So at the point of seizure, that point if you don't take activity of expert opinion, how to seize, how to establish, how to make this an evidence, how to make the hard disk processing, how to make its deletion or whatever, because system requires to be deleted even sitting abroad. Not necessarily that my email will be deleted only sitting in Calcutta while I am using my laptop. By using my password, I can delete the communication sitting in other side of the country. If that is permitted, then automatically it is the expert who is going to retrieve the deleted components. It's available and they are doing it, tracing. Deletion does not mean it is deleted absolutely. It can be retrieved by the expert under forensic test. That is my submission. Even these are all the cases. Let me we have discussed this digital evidence. Jurisdictional overlaps. Offences often invoke both IT Act, IPC, leading to confusion over applicability, provisions and forum. Cross-border challenges, many cybercrimes originate, that is what we have discussed, outside India, complicating investigation and prosecution. Now here, extraterritorial jurisdiction. If you look at the this Bharatiya Nyaya Samhita, section 1, subsection 5, they have indicated that what is extraterritorial jurisdiction. Even section 79 of the IT Act also indicated extrajudicial, extraterritorial jurisdiction. Lack of uniform interpretation, that is very much there. And next, technological evolution. Law often lags behind fast-paced tech. These are actually conceptual part. Let me skip up because time is very short. Up to 1:30? 1:30? 1:15. Okay. Ambiguous definition, difficulty in interpreting legal provisions due to undefined or broad terminology. Now here you will find the fraud has been defined in a different way. That I will show you the slide, next certain slides. Vague legal language. Section 68 of the IT Act uses broad terms like dishonesty and fraudulently. Now what is dishonesty and fraudulently? Unless it is indicated in a clear manner, it is very difficult for projecting the charge sheet or the adjudication. Main series of cyber offences. This is very important for you because culpability of mental state of the convict, of the accused. Main series, that means knowledge. That knowledge needs to be established, as you know, in the adjudication process. So this knowledge is a virtual one. So this will activate only when you are going to have a nuance with the electronic evidence vis-a-vis Indian Evidence Act. Bharatiya Nyaya, what you call Bharatiya Sakho Samhita. Okay, so these are important factors, and that evidence will be made available only by the forensic expert. But investigation, because you are recording a summon, you are recording a statement, and statement under the IT Act, the virtual statement is also acted as an evidence. In other law, if somebody give a statement sitting in USA, an US national, it will not be taken as an evidence, but it will be taken as an, क्या बोलते हैं उसको? Just you put it unless that person comes and give evidence, give as a witness that this is my expert's opinion. A forensic expert's opinion in the matter of IT Act is taken as a direct evidence. The forensic expert may or may not be available unless it is required by the adjudicator. But in other law, this evidence under Indian Evidence Act or Nyaya Samhita, it is not available because the person has to depose that this is my statement. But here in the IT Act, the person need not come, he is exempted, unless the adjudicate needs it for certain reason. This is very important area and rightly observed by the drafter of the law. And mens rea is not a must. I mean, it's a must, I should say, but mens rea can be identified if the substantive technical experts are substantiated as a digital evidence. That this is my data, who is going to say? The forensic expert. The ownership of my data will be available and indicative as evidence once substantially stated by the forensic expert. Am I clear to you? Because the processor is there where the data are there. So who has created the data, how the data have been created, what research has been made, all there in the computer. Ingredients. So that will be made available under as digital evidence. So that could be available by the traditional doctrines misfit. Conventional legal concepts such as physical possession, direct possession, or tangible harm often do not align with the virtual nature of cybercrime, complicating the adjudication. Am I clear to you? These are the points to be noted while investigating the case or interpreting the law. This we have already discussed. The interpretation, what are the available acts and sections. Section 69 of the IT Act, government issues direction for interception like search and seizure and all these things like that. 43A of UAP, that is very important because 1967, that illegal activities and like that. So there is certain empowerment to arrest, investigate. What has happened is, if you look at one point, somewhere in the IT Act or other acts, substantive act, there has been a notation that any other law for the time being in force. In my National Academy, while I am indicating the making a submission before my investigators, investigation and officers, I am trying to project this point only because every investigator is trying to confine himself only on the issues which is available under his substantive act. But while it goes to the adjudicator, suo motu, he cannot raise the contravention which is available under any other law for the time being in force, unless it is projected in the show cause notice or charge sheet. Am I clear to you? So, when you are drafting the charge sheet or drafting the investigation report, if certain other activities which are found to be contravening, it needs to be projected in the charge sheet, no matter whether it is a substantive or non-substantial. Unless it is projected, why legislature has provided any other law for the time being in force? Because you to establish that whether this particular contravention attracts any other contravention of any other law, though it will attract double jeopardy, but you have to project it in the charge sheet, because you do not know while adjudicating the case, while judging the case, where the judgment comes against that section or this section. This is important, and that is why I said when you are taking IT Act, other acts, if it is available, please project it. Section 18 is very important. Constitute Data Protection Board of India, DPBI, and their responsibility is both. I have discussed already, summoning and enforcing attendance of any person to examine them under oath, to produce documents relevant to the inquiries, to inspect any data book, so and so. DPBI is also in power to adjudicate the offences relating to IT Act violation and cyber crimes. So there, this actually Data Protection Board, it is not yet constituted, but once it is, rules are framed, constitutionally it will be constituted, but they will have dual power. As per the draft, it is indicated that there is a dual power. What is the dual power? One is civil proceedings, another is criminal proceeding. Now in the civil proceeding, they will have a compensatory order, compensation, and in the criminal proceeding, it will act as a criminal proceeding and the IPC will take care of it. This is important factor, and that is what is available under DPBI, unless they have the certain framework constituted under the rules, which requires a very substantive inspection, and rules need to indicate what is the powers of the DPBI. Unless the powers are indicated, it will be challenged in the court of law. Independent power of DPBI has to be there, because you will agree with me that an adjudicator, how can he be empowered both under civil law, civil proceeding and criminal proceeding? But it is a matter, maybe you will be in a better position to understand this, but my analytic point is that unless it is clearly indicated, probably it will be a challenging section. Judiciary plays a role, ensuring fair trial, upholding constitutional safeguard, including right to freedom of speech, expression, and recognizing digital space, adapts legal reasoning to the evolving nature of cybercrime. This is very much there. If you look at them, if you look and examine different points in the case studies, really hats off to the judiciary. Not that because my participants are here. I am very well understanding the position that judiciary plays a very vital role, because we are still in the primary stage, so far as the cyber crime is concerned. And there has been often, as a layman, it might be seen that the adjudicator or the judges have misjudged the case. Maybe, as a layman. But really, if you from analytic point of view, there is a substance behind that. And that substance is required from you, the interpretation of the sections and the rules thereof. You will find the case study is the fundamental right expression of speech. A person who has made a crime, fraud in the banking system, in the advertisement, the Shreyas Singhal case very well indicated that 66A of the IT Act is void ab initio. Very good, excellent, I should say. We have been implementing 66A for a long time. But now, after the judgment, we have understood the problem and we have deleted ab initio. Under whose responsibility? Interpretation of law. Adapts legal reasoning, addresses cases involving digital. A judgment often involve imprisonment fines to the offenders with IT Act bearing primary legal framework of such adjudication. Now here, Data Protection Board of India, after doing the civil proceedings, he can very well proceed give a suggestion of activating criminal proceeding. It is available under section 43 of the IT Act. These are the notable cases I have taken from law journals and all. I have to acknowledge the law journals and other people who have actually made these case studies available in the internet. So that is why I have placed their names, their things. State of Punjab versus Amritsar beverage. This, slides I am going to share with you. You may write or may not write. Shreyas Singhal and Union of India landmark judgment striking down section 66A. Sanjay Kumar and State of Haryana, very important case, involved digital evidence and procedural fairness in cyber fraud cases investigation. This Sanjay Kumar and State of Haryana case is very important. These are the cases I have just cited. Please go through the internet and take a note of the entire argument and the facts of the case, so that you can have a clear idea of what is available under the law. Sony Sambat case, BSNL, Baje.com case. You know, under the statute, under the law, if there is any data or any process where the, obscenity comes up, the data individual who have made the data, his consent was not there to the intermediary or fiduciaries to advertise this in the same way and use this as an obscenity. But courts or the investigator or the law enforcement authority has identified this as obscenity, advertisement. At that particular time when this Baje.com case happened, at that time, as I told you, 21, this intermediary, responsibility of intermediary has come up in the year 21. It is pre-21. So they have said that this particularity, there is a system that he has to delete that particular data after informing the authority concerned as well as the individuals who has created the data. In case, am I clear to you? Now what has happened is, indicator, the individual who is the data holder, they have said that I have no knowledge that the intermediary have utilized this my data where the obscenity is pictured. I have not made this data for the purpose of obscenity. But the intermediaries have done this. Then intermediary has projected in the argument indicating that I have no knowledge. The individual who has created this thing, he said, I have no knowledge that my data has been utilized for obscenity. Clear? So, court has exonerated the individuals. Clear? Now, Baje.com, they have not deleted this though in the argument and the court has said that it's obscenity. And that time the intermediary's responsibility was not there. So court has exonerated the individuals, data owner. After this judgment of what is called exoneration, then this Baje.com, after a gap of some time, they have tried to dispose of their application to some other party. Then they have not deleted that data. They are supposed to delete because they have knowledge that this could be utilized in obscenity. So once that knowledge is established, because they have seen that argument and the observation of the court, though the law does not permit him to convict the breaches of data breach, but the knowledge has been established by this application, apps. Then once you have the knowledge on that time you could have deleted that, because observation in the court is there, though the order was not there, conviction. But at the time of changing over your administration, you should have deleted that data. So in the next judgment, they have convicted the data individual. This is the entire judgment. I require you to have a total look of the argument and judgment. It's very important. At the first stage, because of non-availability of the sections of the law, the court is closed, no hand. But once that, because they said that blocking of the datas are available under the law. In the next stage, the enforcement authority said, why did you not block it? At the first stage he said that you had no knowledge. Okay, I agree. But once this is in the court has observed this in the argument, you have the knowledge. So once you have the knowledge, you should have deleted. But while you are changing the administration, you have not deleted the data. So you are punished. Clear? This is very important, and that is why I am trying to explain you. Another 5 minutes. This we have discussed earlier. Challenges in cybercrime investigation. I have just drafted something. Outdated legal framework, lack of specialized unit, jurisdictional complexities, limited international cooperation. These are the challenges which needs to be intervened and supplemented, so that, because in the digital world we need development. Because you and me are involved-minded. During my preamble, presentation, I have said, my own son has been victimized. Try to understand this. He was crying over phone that I have lost 1,50,000. But in those days, the substantive or laws were not there. So what happened is, bank people called the chairman of the American Express Bank. I mean, the authority concerned, police or something, in the matter of CBI's influence, which I have taken up. Naturally, it's my own damage. Then he called the chairman, and I remember my son was telling, the police officer told the chairman, you immediately credit the amount to his account. If you don't do that, I am going to arrest you. But so, mind it, you and me are involved, so development and evolution of the regulations and rules are very important factor. Delayed access, lack of harmonized law, non-cooperation. These suggestions are very much there in the net also. You can very well examine this, how this has been projected, because you need to read, you need to study the media, statements and media factual, these things. Risk, okay. Case studies, these are the case studies, most of the cases are very much there, but PNB case is very important because here the compensation order was there. Now, mind it, the OTP, the password and the OTP or whatever, this ID has been communicated by the victim. Once this communication was made, that means the responsibility of the victim needs to be shared. This judgment indicated that PNB also cannot absolve his responsibility by not doing the risk factor. The risk factor means that the money is withdrawn from this savings account and money is transferred to another account, and that accountability or identification of the next account holder is your responsibility. And there, the judgment passed by some authority, they indicated that as a compensatory order, it has to be shared both by the victim as well as the PNB bank. It's important law. Because that is why one has to be very careful while communicating online. It's very important. Not at every time, everywhere I find that in Kolkata also, every day friends are telling, "Bhai, हमारा laptop में Calcutta Electric Supply Corporation का एकदम पैड में, उसका एप्स में हमारा नाम आ गया, पूरा मीटर नंबर दे के बोलता है जे 20 रुपीज नहीं देने से टुमारो डिस्कनेक्ट हो जाएगा." So how he can say that it is manipulated? It is malware communication. It is spyware. He is not a technical man. So he just has a protective measure. He said, "right, 22 रुपया क्या है? 20 रुपया कुछ नहीं है, दे दो भाई." जैसे ही ऑनलाइन में 20 रुपीज देने वाला, चला गया 2 लाख. This is very important factor. Awareness is very much important, and that is PNB case study is important. And these are penal sections, punishable. These are all there available in the laws of the country. Shreya Singhal case you must read. These are important cases. Once I am sharing this with you, please go through. Unless you have certain questions, I will explain. Otherwise, I have expired the time. See, Supreme Court eventually struck down 66A. Indian judiciary, that is my compliments to every judiciary. Indian judiciary has made significant strides in interpreting and applying legal principles in cybercrime cases, as evident from judgment such as State of Punjab, US versus Ram Babu Saxena, Shreya Singhal and Union of India. One more judgment which I have not cited, it is a extraterritorial jurisdictional issues. You must read versus Microsoft Ireland case, Microsoft versus United States. Microsoft Ireland case, Microsoft Corporation versus US. The fact is, drug trafficking case, this case you kindly read, where how implementation of extraterritorial jurisdiction is available for the purpose of cybercrime. Though under section 79 of the IT Act, we have amended and implemented the extraterritorial jurisdiction as not only India, but outside India also has been implemented, incorporated, very late, of late. But this is old case. But what is extrajurisdictional, extraterritorial area? To understand this case study is very much important. Conclusion, the same thing I am telling you. Judiciary, through interpretation of various statutes, is progressively adapting traditional legal principles to the digital age. This evolving jurisprudence reflects a comprehensive approach to address the complex and dynamic nature of cybercrime. By aligning legal reasoning with technological realities, the judiciary plays a pivotal role in combating digital frauds and ensuring justice to the cyberspace era. Thank you very much. All the best.